The US Supreme Court rules on whether or not states can keep money that has been abandoned within their state and which states have claim to the money that's been abandoned, how you determine the place of abandonment. Let's get started with this. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal educational content, and today is the day I earn a subscription. For today's story, we are talking about a United States Supreme Court decision that just came down. It is Delaware versus Pennsylvania, a case of original jurisdiction before the US Supreme Court, which means the Supreme Court is the trial court, because that's how we roll. There is a dispute between Delaware and Pennsylvania regarding how money abandoned is assigned to what states. How do you determine that? Which state gets to keep abandoned monies? If no one claims that money after a while, then the state gets the money. But then the question is, which state? How do you determine that? And that is the dispute. Let's learn a little bit more about this. Delaware versus Pennsylvania, case of original jurisdiction. On exceptions to the report of the special master. So, as is common when the US Supreme Court has original jurisdiction, they are the trial court. They don't typically really do it. They assign it to someone else, but they are still the trial court, which means they can do whatever the hell they want. Everything is de novo. They can look at the special master and just completely ignore them, but they don't tend to do that. The court has assigned someone to provide a recommendation, and the court has to decide whether or not to take that recommendation, but the Supreme Court can do as they wish. A state may take custody of abandoned property located within its border. This is known as escheatment. When abandoned property is intangible, however, the lack of physical location means multiple states may have claims. If you're abandoning physical property, you leave your car on the side of the road for a long period of time or whatever it is, however you determine abandonment, or for that matter, abandon real property, you just leave your house. Maybe it's been abandoned, right? At some point, through some mechanism, the state says, yoink, my property. But if it's not physical, what do you do? In these cases, the question is which state has the right to escheat two financial products sold on behalf of MoneyGram, agent checks and teller checks. Operating much like money orders, both products are prepaid financial instruments used to transfer funds to a named payee. When these prepaid instruments are not presented for payment within a certain period of time, they're deemed to be abandoned. And currently, MoneyGram applies the common law escheatment practices outlined in Texas versus New Jersey. So there are some rules, basically, how long does this money order like instrument remain valid? How long do you have to do it? You might be familiar with the idea of a stale check. Check beyond a certain period is stale. A lot of banks will refuse to cash a check that's more than 180 days old, for example. And in this case, if it becomes stale enough, then it's deemed to be abandoned. The court established the rule that proceeds of abandoned financial products should escheat to the state of the creditor's last known address, or where such records are not kept, to the state in which the company holding the funds is to be incorporated. Because MoneyGram does not, as a matter of regular business practice, keep records of creditor addresses for two products issues, it applies the secondary common law rule and transmit the abandoned proceeds to the state of incorporation, that is Delaware. Okay, so what we have going on is this idea of who's the creditor. Who is the person the check is made out to or the money order made out to? MoneyGram doesn't keep this information, or at least they don't have the address of the person. It's just made payable to somebody, and they don't know who it's made, who it is, which they honestly probably don't. When you go and you order a money order, they don't typically ask who it's for, and they certainly don't keep records. So they don't know. What they know is they have a money order that was issued. They know how much it was issued for. They know the date it was issued on, and they know whether or not it's been cashed, but they don't know who the creditor is. So the rule is if we did know the creditor and their address, then it would be deemed to be abandoned in that state. So if we did keep a record and said, it's owed to Joe Smith. Joe Smith lives in Florida. Then the rule would be Florida gets the money. But they don't keep those records. If you don't know where the creditor is, how about the place where the business is incorporated? It is money that the company owes. You give your money to MoneyGram. They issue this thing, they have to pay it out. So they're holding it for you and it's on their books. And then after a while, it hasn't been paid. We don't know where it's supposed to go. It's not our money. It was never our money. We were just holding it for someone else and it's sitting on our books, but it's not really our money. So how about the state of incorporation gets it, which is Delaware? So Delaware gets all the money. Great for Delaware if you're Delaware, because no matter where this MoneyGram is purchased, it's on the books in Delaware. So when the money goes abandoned, Delaware gets it all. Delaware likes money. So they'd like to keep all the money. Okay, let's read a little bit more. Multiple states have invoked this court's original jurisdiction, which is what happened when one state sues another. They file in the US Supreme Court as the trial court to determine whether abandoned proceeds of these instruments are governed by disposition of abandoned money orders and traveler's checks rather than the common law. There was a common law rule, but Congress perhaps wrote a different rule. So let's go see if that applies. The relevant law provides that a money order or other similar written instrument other than third-party bank check should generally escheat to the state in which such instrument was purchased. All right. So now we have a different rule. Under the common law, how about the state of the creditor? The person who the money is going to. We don't know who that is. All right. Fine. How about the state where the company is based? Delaware. That's the common law. Congress comes along and writes a federal law because it deals with interstate commerce and says, okay, if it's a money order or a similar instrument, not a third-party check, right? So third-party check, like issued by a bank, different rule. But if it's a money order, we're going to modify the common law and we're going to say where the instrument was purchased. So Delaware is going to lose a lot of money. Delaware is sad. If this is a money order, because all those funds, now they have to share with all the other children. And they'd like to not do that very much. The court consolidated the various actions and appointed a special master, as they do. They appointed someone else to referee this because, they can't be bothered. In the initial report, the special master concluded the disputed instruments were covered by the federal law. These are money orders, says effectively the special master. Following oral argument in this court, he reassessed that decision and introduced a second report, concluding that many of the disputed instruments were or could be third-party bank checks. So are they money orders or are they third-party bank checks? He says some of them are third-party bank checks, which are excluded and would escheat to Delaware. All right, so that's the question. Are these third-party bank checks or are these money orders? So he says, okay, some of the time, they're third-party checks. U.S. Supreme Court, being the court of original jurisdiction, says the disputed instruments are sufficiently similar to money orders to fall within it. So the U.S. Supreme Court just disagrees with the special master flat out, which they can do because they're the court of original jurisdiction. They are the trial court. So the recommendations from this would be roughly equivalent to a magistrate in a typical federal court. Magistrates often handle matters and they work for a federal judge. And if everyone's happy, then the magistrate can do lots of stuff. They can't do all the things, but they can do lots of things. And depending on the nature of the case, sometimes the case can be completely resolved by the magistrate. Sometimes, at least, you can refuse to have a magistrate and be like, I want my case decided by a federal judge. And even where you consent to a magistrate, you can appeal, although strictly speaking, appeal is the wrong word, because it's not an appeal, because the district court is the court. The magistrate works for the federal court. And so many times the district court will say, I agree with the magistrate, but not all the time, and they don't have to, because they're the trial court. They can be like, that's nice, magistrate, and all, no. And so very similarly, the U.S. Supreme Court's in basically the same position. They've appointed a special master, and special master's like, how about third-party bank check? And the Supreme Court's just like, no, they're not. They're money orders. Delaware just lost a lot of money. Delaware just lost a shit ton of money. Delaware is sad, but that's where we're at. Delaware is going to have to write some pretty big checks of their own here in about a second. The disputed instruments share two relevant similarities with money orders. First, they are similar functionally and operationally. Although the relevant federal law doesn't define what a money order is because that'd be way too convenient, a variety of dictionary definitions contemporaneous with the Act passage universally define a money order as a prepaid financial instrument used to transmit money to a payee. And this court's common law precedent, the backdrop against which the federal law was enacted, accord with that definition. So Congress, in their infinite wisdom, didn't define what a money order is, but this court had talked about what money orders were preceding the act, and the dictionary definitions are in alignment with that. So we're going to assume Congress just wanted the definitions that were in existence at the time. So fine. In addition, the features that money orders share with these instruments, the fact that they are prepaid, make them likely to escheat and thus implicate the law in the first place. Second, due to record-keeping practices of the entity issuing and holding on to the funds, abandoned money orders and the disputed instruments both escheat inequitably under the court's common law rules. Delaware currently gets all the money. That's not quite fair, is it? The federal law was passed to abrogate this court's common law precedent precisely because, for certain instruments because money orders, the entity selling products often did not keep adequate records as a matter of business practice, which meant that the law mandating escheatment to state of corporation always applied. So this was the reality before, as it is the reality now. MoneyGram doesn't keep records. Neither did anyone else. They don't keep these records as a matter of their business practice. So Delaware always got all the money because all the businesses are incorporated in Delaware. And Congress thought that was a little unfair. The federal law prevents this windfall to the state of incorporation by instead adopting the place of purchase rule that distributes the money as a matter of equity among the several states, which, when it's Congress passing law, as long as it's within their authority, it's not fair is a perfectly reasonable reason. That's what Congress does. Congress does policy. So it's not fair, okay. Because MoneyGram doesn't keep these records, application of the common law would produce the same inequitable results that the law was designed to solve. Delaware doesn't get to keep the money. Delaware's contrary arguments are unpersuasive. Their contrary arguments mostly being, we're about to have to write some really big checks. First, the state contends that money orders refers to a specific commercial product, labeled as such on the instrument, and sold to low-income individuals. So money order is only a money order if we call it a money order. If we call it something else, it's no longer a money order, even though incidentally the law says money order or similar instrument, because Congress wasn't this dumb. But even if it literally said money order and nothing more in the federal law, the courts wouldn't be this dumb. We didn't call it a money order, therefore it's not a money order. Yeah, no. Unable to present a dictionary definition that cabins the term as described, lol, no. Delaware attempts to highlight the various way in which disputed instruments differ from money orders. Okay, they're not money orders because reasons. But Delaware never explains how these differences are relevant or how such differences undermine the similarities. They're not money orders because things. In an effort to make these differences more relevant, Delaware asserts that the law was actually concerned with dissuading the states from adopting costly record-keeping requirements that would then be passed on to consumers. What? Delaware argues the disputed instruments are unlike money orders in that consumers of the instruments are typically more capable of absorbing the cost of record-keeping. What? The text, however, does not support this argument. No. This was really concerned with the record-keeping requirements. What it says is nothing like that. Finally, Delaware's suggestion that the law be read narrowly to avoid creating surplus and sweeping in all sorts of unintended financial instruments goes too far. While there's some merit to Delaware's concern about a broad term, money order, this court not need actually define the term, as it suffices that the instruments in question be similar to money orders. So, first of all, if it literally said only money order, we'd still probably be making this exact same decision, by the way, because we're not that dumb. So even if, unless, of course, the language was more clear, right? So Congress could, of course, only make this so it would only apply to some strict version of money order, right? So Congress could do that, but probably didn't do that because we just merely changed the label on the thing. It's not normally how we deal with this, but Congress thought one step ahead. Congress was a smart Congress and wrote similar. So are these money orders? We don't have to actually decide if these are money orders or not because the law itself says similar. So there's that. That makes our life a lot easier. Both Delaware and to some extent the special master claim that even if they qualify as an otherwise similar written instrument, they're also a third-party bank check. So let's give that a try. They're really a third-party bank check. The problem, of course, is that the law doesn't define that phrase either. Because why would Congress define things? Nor does the phrase have a commonly accepted meaning. So the Supreme Court's like, we're not really sure what a third-party bank check is. Delaware insists the term means a check signed by a bank officer and paid through a third party. But the state provides no theory as to why it matters to the sheetment rule whether a financial instrument is or is not paid through a third party. In a second interim report, the special master offered the view that third-party bank check was intended to exclude from the reach certain well-known financial instruments upon which a bank might be liable, specifically a cashier's check, certified check, and a teller check. And thus, to the extent a bank shares liability with MoneyGram or the dispute instrument, that product should be characterized as a third party. And thereby excluded. The special master did not explain why Congress would use the amorphous term to describe a well-known financial product, while also calling out other well-known instruments, such as money orders, by the name. Nor did the special master explain how bank liability relates to the rules in any meaningful way. Bank liability also doesn't seem to be the tipping point for exclusion from the law, given that banks can be liable for money orders. So banks issue cashier's checks, to be sure, and teller checks. But you know what else banks sometimes issue? Money orders. Some banks issue money orders. They call them money orders. They're money orders. So the fact that the bank is liable is not dispositive. Because whether the bank is issuing the money order or whether or not MoneyGram is issuing a money order, it's a money order. So it can't be because the bank is liable, therefore not money order. That can't be right. Yeah. Finally, legislative history on the law does not support the contention. Disputed instrument constitutes a third-party check. The well-documented circumstances surrounding insertion of the phrase support the conclusion that whatever the intended meaning of third-party check, it cannot be read broadly to exclude from the large swaths of prepaid instruments that is sheet inequitably. So this is not a third-party check, is basically the bottom line. Judge Jackson issues an opinion for unanimous Supreme Court, and with respect to some other part in which 5 members join. Yeah. So Delaware is sad because Delaware has to write some checks. Or I suppose money orders will also be fine. Somehow I feel like those particular money orders will not go abandoned when they're sent to their respective states. But yeah, that sounds about right. The law says money order or similar instrument, and these look suspiciously like money orders. So the special master said some of these things are really third-party checks because these money orders are also backed by banks. And the Supreme Court said, no, they're not a bank check. They were issued by MoneyGram. MoneyGram is not a bank, so they're not a bank check. No. So yeah. So that's fun. Delaware has to send some money.